In 30 minutes, I got to finish quite a lot. I got about 20 slides to finish. So now, let's see under English law. So you have seen the importance of having a will. You have seen the importance of having Islamic will. Now, I want you to focus that we are staying in UK. UK got its own requirement for your will to be valid. And there are many acts of parliament on that. I'm not going to go into detail. I just focus on what you got to know. First of all, under the Wills Act, 1857, your will must be in writing. It must be in writing. Number two, it must be signed by you. You must sign it. I had a case when I was practicing law in South Africa. A father left 4 wills. He never signed anyone. He never put any dates. We didn't know who gets what. And it was a big, big problem in court. So make sure you sign it. Okay? Number 3, you must have 2 witnesses. They don't have to read your will. They got to make sure that you are the person who have signed it. That's the purpose of the 2 witnesses. And make sure that the witnesses are not a member of your family who will be an heir. Your wife cannot be a witness. Your children cannot be a witness. Your father cannot be a witness. Understand? These are the conditions of UK law. Next one is your mental capacity. Please, brothers, listen to me properly. If you look at the statistics of UK, we're having an aging population. An aging population means, in practice, we've got experts sitting over us, our cognitive, we're having a digressive cognitive. We cannot think. We have dementia. We have all type of disease, mental disease. What would happen under English law if you cannot understand what you are signing, what you are giving away? This will be challenged. I personally had to give a legal opinion on a case, a multi-millionaire, not to say billionaire, I think he's a billionaire, where he had 2 wives. One wife, children, were not so well off, were not so mature enough. The other one was a big gap in age. So they challenged that the father, the will that he was doing, his action, everything, he was having a starting of a dementia, the starting point. There are 3 stages of dementia. They were challenging that, and they were challenging all the documents he signed. I'm not talking of thousands, I'm not talking of millions, I'm talking of billions. Right? Because of dementia. So you got to make sure you got the mental capacity. So if you are afraid that children can challenge it tomorrow, Mr. A can challenge it, make sure that when you draft it, you can go to a notary or a lawyer, that you are signing it and you know you are in your senses. You know what you're signing. Make sure this. I got another case where a person challenged the will that this man was his old age. He doesn't know what he did. He gave the house to Mr. A. Mr. A doesn't deserve that house. But Mr. A was very sharp. Mr. A got, when the man went to sign, he made it sign, he knows what he was signing. He presented that in court, he lost the case. He got the house. So these things are happening in society. You will only understand what I'm telling you when you be subjected to that. Yes, yes, yes. Right now you don't understand what I'm talking because it's not haunting you. Okay, it's not haunting you. So take this precaution. So mental capacity. Next. You got to do it voluntarily, no coercion, no undue pressure on you, right? And one thing which is not in the act, always revoke, have a revocation clause, because you don't know what you did when you were 20 years ago, 30 years ago. So revoke. Know what you are doing. That was your final document, right? Next. Now the condition for a will to be valid, number 1, you must be 18 or above 18. You must be sane. You must be free, no coercion. You must be mentally sound and understanding what you are making a will, because the mental diseases are increasing in UK. We're having an aging population. Know the nature and extent of property and potential beneficiaries. It must be in writing, must be signed by the testator. How two witnesses at time of signature. Witnesses must sign after the signature of the testator. You can add an attestation clause, they say, that is, I have witnessed that he is that existing. If you want to put an attestation clause, and a witness or his spouse cannot benefit under the will. So this is what I've said. So these are the conditions that if you are to draft a will, for it to be valid in court, provided it's not against public policy, it will be okay. Right? These are the conditions that when you prepare a will, it goes to the probate officer. It must be writing, it must be signed, you must have two witnesses, you must have the mental capacity to prepare it, you must be above 18, this type of things, right? This is the law in UK. What you put in there, the law gives you the freedom. Who you want to give what, the law gives you the freedom, provided it's not against certain policies in UK law. Next, please.
So it doesn't need to be notarized?
No, doesn't have to.
But it's better if it is.
Yeah, if you want. Right. In any case, a solicitor is an officer of the court. He is regulated by the Solicitor's Regulation Authority. So all this got value in court. Yeah. Now, there is something about the legal capacity. I've taken the position of Ali To's article here, which I got from LinkedIn, which I found very, very from a law website. The question of mental capacity. I'm not going in depth with that. I need about 30-40 minutes to explain only this word. There was a case in 1870 called the Banks versus Godfellow, where the court says when you talk about mental capacity, it means understand the nature of the act of making a will and its effects. You've got to understand, when you're making a will, what is the implication? Who is getting what? Number two, understand the extent of the property of which they are disposing. Right. Number three, be able to comprehend and appreciate the claims to which they ought to give effect. Number four is a problem here. Not be suffering from any insane delusion or disorder. Look at the English law, look at you. Want to protect you, protect your state. Why I'm saying number four? Because this is 1870. There is a mental, next please, we have the Mental Capacity Act that came, and there they gave other conditions that caused some havoc, it caused some confusion. There was few cases I went to court because of time, I'm not going that. So there was a presumption of capacity, where it is important to remember that both tests operate on the basis of presumption of capacity. Under that case of 1870, that is, you can appreciate what you are preparing, what you are disposing, etc., is in its place. On top of that, medically, you must be okay. You are not suffering from mental disease, depression. What about, there's so many diseases nowadays, right? Because if not, this will be challenged. So the law is protecting you. The law is not complicating your life. The law is making things easy. You don't go unnecessarily wasting money in court. So this is the way to look at it. When you have an act of parliament, the government wants to make things in order for you. Okay, next. So what do you do? When do you update your will? So these are very important. When you get married, marriage can change who will get what. Right? When you go divorce, divorce also, if you have a will, you haven't changed the will, your ex can claim. You've got to redraft your will. Yeah, okay. When you have new children or other relatives you wish to benefit, for example, nieces, nephews, you want to benefit them. With time, you want to change. Have bought a new property or have recently obtained expensive assets, buy a new car, etc. So you've got to relook at your will. On average, we tell people every 2 years, check your will again. If you want to change it, you change it. Yeah? So these are events that will have an impact on your will. Next.